Let's take Lightfoot first. 25 CR 715, Montreal Lightfoot. You have to speak out so she can hear you.
Montreal Lightfoot.
Okay. You are here with Mr. Burbank, your attorney, and the state's attorney is present. You were charged with the third-degree felony of deadly conduct, discharge of a firearm, which carries with it up to 10 years in prison. Do you understand?
Yes, ma'am.
All right, this states that the defendant, probable cause affidavit I'm referring to in the file here. And that the defendant and another person fired multiple rifle rounds into an apartment complex parking lot, resulting in 2 people sustaining gunshot wounds. And multiple apartments, occupied and unoccupied, were struck by gunfire, as well as multiple vehicles were hit. And according to the surveillance footage here, AR-15 style rifles were used in the commission of this offense and this shooting. Montreal Lightfoot is identified as one of the persons involved in the firing of the weapons. What is his bond now? Are you asking for a reduction in bond?
Yeah.
What is his bond right now?
Yeah.
Right, Cassandra.
$150,000.
Which apartments are these? It says 4610 Maddox. I'm not. What's the name of that apartment complex?
Judge, I've just been very, we had to sort out who all was handling these. There are 6 co-defendants, and I now actually have all the cases. There is an apartment complex that is located on East Virginia and Maddox, but I apologize, I don't know the name of it, Judge. But that is where this happened.
Yeah, Lightfoot, what do you want to say? Mr. Burbank, you're asking for a reduction of bond, and the bond is $150,000. Is that what it is?
Yes.
Go ahead.
I can put him on if you want.
What do you want to do? Whatever you want.
We're asking for a reduction to 50,000.
What do you want to do? Do you want to put him on?
I can put him on if you need to.
I don't need to, whatever you
I
want.
can shortcut it.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing, sir, will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And please state your full name.
Montreal Lightfoot.
Okay, and your date of birth is September 29th, 2006, correct? You have to speak out.
Yes, sir.
Okay. Yes, everything. Yeah, you nod and shake your head. It doesn't work. She's got to take everything down so that we can have it for a record. Go ahead, Mr. Burbank.
Montreal, how old are you?
18.
18. And do you have any bank accounts or any money that you could possibly post a $150,000 bond?
No, sir.
Do you have any vehicles? Do you have any property that you could put up as collateral for a bond?
No, sir.
Prior to being incarcerated, well, how long have you been in jail?
4.5 minutes.
4.5 months. And before that time, were you a resident of Beaumont?
Mm-hmm.
And who were you living with?
My mom.
And your mom. And if you were to be able to post bond and get out, would you go back with your mom?
Yes, sir.
Where does she live?
Straightaway.
Straightaway? Okay, and she has a place for you to stay, correct?
Yes,
You
sir.
get rid of your bed, huh?
Yes, sir.
If you were to get out too, you would abide by all the rules and conditions.
Yes, sir.
One might be a GPS. They want to know where you're at.
Yes, sir.
Would you be able to do that?
Yes, sir.
There may be a curfew saying that you can't go out all hours of the night. Would you be able to do that?
Yes, sir.
And you're asking for a bond reduction at this time?
Yes, sir.
We're asking your honor that it be reduced down to 50,000.
Stay. Any questions?
Did you graduate from high school, sir?
No, sir.
Are my records accurate that you've not been arrested before? Never had any juvenile history either, is that correct?
No.
Those are my only questions, Jeff. For the defendant.
Look, the court is looking at the public safety report as courts are required to do on taking issues of bond. I'm looking on at this report. It was printed out on June 13th of 2025. And it the defendant, among other things, it discusses the charge here in this indictment 25 CR 715, deadly conduct, discharge of a firearm. And it also states the defendant was in July of 23 evading arrest or detention, a Class A misdemeanor, was referred I guess juvenile disposition. May 26, 2023, illegal possession of a dangerous drug, a Class A misdemeanor, that was referred. On November 15th, 2021, state jail felony of unauthorized use of a motor vehicle, that was adjudicated, and the defendant was placed on 1-year probation. And on November 15th, 2021, also an evading arrest with detention, a 3rd-degree felony, adjudicated, placed on probation with the unauthorized use of a motor vehicle for 1 year. That's what this is, that true? Okay, that's not what you told him.
I believe he was talking about his adult side.
Whatever.
No, I asked specifically
That's
about
not what he
attorneys.
asked. He asked for any. It was a global question. But the point is that the public safety report is made a part of the record in this, for this hearing, and sealed otherwise, because this is going to be dealing with some juvenile behavior. So this isn't the first time you've been arrested, is what this says. And this isn't the first time you've been before a court and a proceeding for criminal matters. So you know how it is. You know that consequences, actions have consequences. Good actions or bad have bad consequences. Here, the court is looking at the probable cause affidavit, where there are numerous assault rifle rounds fired in a multi-family dwelling apartment complex here in this city at looks like about noontime. And you and another person were apparently identified as being the or among the people involved in the firing of those weapons. And the 2 people were shot, multiple apartments struck by gunfire, and multiple vehicles hit. In this city, this is like a bad movie. We're not going to put up with obnoxious, bizarre, violent, random behavior where people in an apartment complex, you have all sorts of people from young to old, where you have bullets flying around. This is absurd behavior in a life that we've had enough of violence. We don't want irresponsible behavior, and we certainly don't want people shot or in harm's way. And we don't want an environment where in the middle of the day, there are assault weapons being fired among the homes, multifamily dwellings in this city. We won't tolerate it. And you know from your previous criminal involvement with the crimes of evading arrest, illegal possession of drugs, unauthorized use of a motor vehicle, evading arrests, those all have consequences. And you were placed on a form of probation, it looks like juvenile. So you know that this is serious. But it's the law. We're supposed to live peaceably in this country, much less this city. And it's what we make of it. We are not going to tolerate wild behavior like this, where people are in harm's way. It only takes one bullet to kill someone. Your bond is, if it were me, I'd raise it. I don't tolerate this. The people in the city don't want chaos, especially someone who's been through this criminal system before. Shame on you. So the bond is not dismissed. It is not reduced. If he posts a bond, if you post a bond, you must have a GPS device. You will be at home confinement. You will not leave your home except for necessary reasons and with the court's prior permission. Any reason I want to have, I know what it is, and I'm going to be the determiner whether you're going to be allowed to leave the home or not. But this is chaos, and the people don't tolerate this. No civilized group would ever tolerate this. Shame on them. And anybody else who pulls stunts like this. How many rounds were recovered?
That's a good question, Judge.
Numerous?
It was a lot. I
Yeah,
remember
yeah, only
that.
takes, yeah, that's one for each soul who was at risk.
One of the
Could have
things-
killed a whole bunch of people.
It sent two different people to the hospital, Judge. And,
Killed them.
but I don't
But people's homes were, and vehicles were damaged. Chaos. That's not tolerated. Shame on you. And anybody else involved with that. Shame on you. So, no,
Thank
you can
Judge.
sit in custody until we get this thing finished.
I'd ask that we place on the trial.
It's set for trial.
Move this on,
Sure.
Judge.
Sure. Set for trial and get it fast tracked. I want a jury to hear this and to decide his fate as soon as possible.
If I could, I'd like to get all the defendants on the same trial document. Yeah.
It's on,
I could make sure that are set together, Jenny.
okay. Did I give you back? Did I give you that time? Let me look at it just real quick.
One other thing for your honor's education, in this young man's 130 days in the jail, he's had 9 what they label criminal incidents. So his behavior in the jail is not.
What am I supposed to do?
I'm just educating the court that you're certainly made the absolute right decision based upon his behavior in pending custody, Judge.
Okay. But it's based, I didn't know that information,
Yes, sir.
but I guess I'm not surprised based upon the public safety report, the criminal history, and the probable cause affidavit. You're free falling. You don't care about anybody else. The others, your creator should be first, other people second, and then you third. That's what all humans should be. We should be selfless, not carrying around weapons that can kill anybody and erratically firing those in multifamily dwellings and at cars. The fact that there weren't 20 or 30 people killed here by you, I guess, is a miracle. But it wasn't because of your brilliant thinking. It's just God's will prevented that from happening. But we are going to step in and control you as best we can. Everybody has free choice, and your choices are poor. Anything else? That,
Not from the state. Thank you, Judge.
all right, Kavante Willis, come forward, please. Thank you.
As I pointed out earlier, this is a co-defendant from that same fact pattern.
I have two cases here, though. I only have one.
That's because he's a convicted felon, Judge. He was charged with unlawful possession of firearms.
He's just.
See, brother,
Same, this is the same occurrence.
same fact pattern, yes, sir.
Come on up.
And it's
Two
the
cases are
state
now
belief
called.
he was handling one of the weapons, Judge.
Two cases are now called 25 CR 716 and 717. Kavante Willis, is that you?
Yes, sir.
You are here with your attorney, Mr. Lodge, and the state's attorney. Sir, in 25 CR 716, this indictment handed up on June 11th, as well as 25 CR 717 handed up by the grand jury on June 11th. In 716, this alleges in paragraph 1 that on or about May 5th, 2025 in Jefferson County, Texas, you committed the third-degree felony of deadly conduct by discharging a firearm at or in the direction of others. And then paragraph 2 goes on to allege that you have been convicted out of Lafayette Parish, Louisiana in 2021 for robbery. So if you are found guilty of this third-degree felony of deadly conduct and this prior conviction was indeed deemed valid and admitted at a hearing, your punishment range becomes a second-degree felony, which means you are looking at no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. Plus, you would not be eligible for probation in front of a jury if
Yes,
this
sir.
prior conviction. You going to interrupt me? Yeah, let's follow the rules for a change. That's why you're here. We all follow, and we all have to follow the rules. But you get in trouble when you don't. So once again, a jury cannot grant probation in this state for someone previously convicted of a felony if this is deemed valid. And finally, in 25 CR 717, in this case, you are indicted with the third-degree felony of unlawful possession of a firearm by a previously convicted felon. On or about May 5th, 2025, when you committed this deadly conduct, it is alleged you were possessing a firearm, which then enhances your punishment if you are a convicted felon, as 716 indictment alleges that 2021 conviction for robbery out of Lafayette Parish, Louisiana, shows that you are a convictee. So you are ineligible to possess a firearm if you were previously convicted of a felony in this. It's unlawful in this state to possess a firearm in this manner if you have a prior conviction, and it's a third-degree felony, which carries with it up to 10 years in prison. So totally, you're looking at up to 30 years confinement is what you're exposed to. And in this deadly conduct, whatever sentence you get, it would not be paroled until you served 1/2 of your sentence on this deadly conduct. So if you receive a 20-year sentence, you won't see light of day in the free world until you've served at least 10 years confinement in prison, and you're not eligible for probation. So you've gotten yourself into a box here. You got to deal with it responsibly. She's a fine lawyer. I'd follow her advice if I were you. Do you understand what you're charged with and what the punishment range is here in each of these cases? Why are we here? It's a hearing on what?
Bail reduction.
What is this violence?
Just on the deadly conduct, it's $50,000.
I'm sorry, it's what?
$50,000,
Mhm.
and on the unlawful possession of a firearm, it's $100,000.
So total, it's $100,000 on each case, correct?
150.
$150,000 in both cases added up.
Yes, sir.
Okay. It's your motion. Go
Thank
ahead.
you,
Yes,
Jay.
ma'am.
I'd like to call my client. Mr.
Raise your right hand. You solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God. Lower your hand.
And you're gonna have to speak up for the public reporter to hear you, okay? Mr. Willis, will you tell us how old you are
22 years old.
and how old were you at the time of the incident?
This incident right here,
Yes.
I'm 22.
Okay.
I wouldn't hear of this incident, so
Okay, do you have any current bank accounts or cash on hand that you could use to help pay this bond?
yes, ma'am.
How much do you have available?
I don't even know. This is my daughter bank account.
Do you have the funds available to pay the
Yeah, my mom should have
the entire $150,000?
not the entire 150,000.
Okay. Do you have any property that you could use for collateral to pay the entire $150,000?
I don't think so.
All right. Who were you living with before?
My mother,
And if you were to be released on bond, if you were able to pay your bond, who would you go to live with?
my mother.
And she would still want you to live with her?
Yes, ma'am.
And she resides in Jefferson County?
Yes, ma'am.
Okay. And if you are released or able to pay the bond, you understand that that may come with some conditions
Yes, ma'am.
that might include you to wear an ankle monitor,
Yes, ma'am.
conditions that might require you to be homebound.
Yes, ma'am.
Okay, and you're prepared to follow any of those terms and conditions?
Yes, ma'am.
All right. Judge, we are asking for a reduction in bond down to $50,000.
And she had asked you a question. I just want to make sure that we all think about this real hard. She asked you, and you can follow all conditions that a court would set.
Yes, sir.
There's not a doubt about
No doubt about
May I?
it. So help you God.
it. Can I say something real quick?
Yes, sir.
See, I was already on probation before, but I had completed my probation. Why am I not eligible for probation again?
I'll talk to you about that after this hearing, if that's okay, Judge.
Okay.
May I ask questions?
Go ahead.
You are Kavante Willis,
Yes, sir.
spelling Kevontay.
Yes, sir.
Your date of birth is December 4th, 2002.
Yes, sir.
You were convicted in the Lafayette Parish in Louisiana on August 26, 2021
Yes, sir.
for the offense of simple robbery
Yes, sir.
in clause number CR-179579 in the 15th Judicial District Court located there.
Yes, sir.
Yes, sir.
And on that, you received for that offense, you did receive looks like the equivalent of some kind of probation where you were sentenced for 3 years, but hard labor, but it was probated for 3 years.
Yes, sir.
You were just referencing to the court that you had finished that probation.
Yes, sir.
When did you finish the probation?
I finished in 2024 around March.
Okay, go ahead.
Show you a picture that's in there. Is that individual you?
Yes, sir.
So you're not disputing the fact that you've been convicted before of simple robbery from that
Yes, sir.
deal that we've been talking about. All right, so let's talk about your conduct in jail. My records indicate that you have been in custody for 129 days, true?
Yes, sir.
My records indicate that you have been reported for different incidents of not following the rules starting in June 11th of 2025, all the way up until right before you appeared here in court on the date of September 21st, 2025, yesterday.
Yes, sir.
You want to modify your answer to that you gave the judge that you have the ability to follow rules?
Yes, sir. See, most of the cases I got in fights, but like I got jumped and all the situations, like when it was my fault. Just I'm not from around here, so just I don't know how to explain it. But
No.
I don't have any other questions along those lines, Judge.
Okay.
Anything else would be about the offense. And I'm
Let
not
me
gonna
ask you
go
about the
there.
probation that you were previously on. How did that get disposed of?
You completed the terms of that
Yeah.
probation,
I
correct?
completed the probation.
Or, for 3 years? It was a 3-year term of
Yes, sir.
probation?
It was a 3 and 7 if I violated 3
Was
years.
Was it February of 21?
Yes, sir.
No, that's the arrest date.
I believe
When-
that.
when were you placed on
conviction date
probation?
was August
August.
21.
August of 21.
August of 21, which means he's been a little over 4 years
But when did he get off of, when was he released from probation?
last year.
In 24.
24. Yes.
The actual notes in our record says he was released unsatisfactory. That's from the custodian of the records for the pin packet that
Yeah, I'm
was
not sure
received
what
and
that
uploaded.
exactly means. That doesn't sound good, but I don't know what it means, really.
And in fairness to all of us, Your Honor, I also don't know what that means. From his understanding, he completed the probation. He didn't get any further.
Sentence?
Yes, so
So it ended with a probation, but it's a regular probation. He was found guilty,
Yes,
Yes.
not deferred.
Correct.
You were
Regular
found
probation.
guilty beyond a reasonable doubt. That probation was not dismissed, though, and exonerated. He wasn't.
Correct.
it-
It's our equivalent of a straight, it's our equivalent of a straight
So
probation, yes, sir.
So you have, and that's why this is alleged here as a prior conviction in paragraph 2, which they're going to argue at trial feasibly that you're not eligible for probation because of this, if it's proven true beyond a reasonable doubt, and that the punishment range is enhanced. It's higher because of that.
And it's that conviction the state is relying on for him to be a felon in possession of firearm, Judge.
and just for judge's clarification, what age were you at the time of that conviction?
17.
17 at the age of that conviction, Judge.
Did you know better?
Yes, sir.
What?
At the time, I know better.
I was 17 months. I know better than
Yes, I know
to
better
commit
now.
robberies.
Yes,
I mean, how old do you have to be to know that a violent crime is real? All right. I have the public safety report as well for this record, which was printed on June 13th, 2025 of defendant Kavante Todrick Keon Willis, date of birth December 4th, 2002, FBI number R as in Robert 0320, P as in Paul, J as in John, W as in William 1. It is a document of 3 pages, which will be made a part of the record for all purposes for this hearing, since the courts are bound to recognize and review the public safety report of an individual who is the subject matter of a bond hearing now under Texas law, and it has the criminal history of the defendant as well as the new charges. All right, you're asking Ms. Naraj for.
Yes, Your Honor, we're asking for a reduction in that amount to 50,000, something that is potentially capable for him to pay.
Understand. The court has also reviewed the probable cause affidavit in this case. And again, this is a most aggravated, serious case where multiple rounds of AR-15 style rifles were fired into vehicles and apartment units of a multi-dwelling apartment complex in this city of Beaumont, Jefferson County, Texas. And 7.62 and 5.56 caliber rounds connected to assault style weapons were fired in this case. And the current bond, the court feels is proper based upon the circumstances of this case and the defendant's criminal history. And shame on anyone who is so irresponsible to fire assault weapons at midday into apartment units and vehicles at a multi-family dwelling facility like this apartment complex here in Beaumont. Your bond is not reduced. If you can post the bond in this case, you will be placed on home confinement. You must have a GPS device. You cannot leave your residence under those circumstances unless a permission is granted ahead of time by this court. Do you understand where you are? And this is all due to the circumstances of this crime and your criminal history. Anything else?
Yeah.
That is all. Thank you.
I have a question.
Yeah, you can talk to her.
Yeah, I
Okay.
can talk to you.
Carly Fowler? Carly Fowler,
That was me.
that was reset. And then we've got, I had Monica Vincent. Did we reset that?
Does that